Good morning, good afternoon, everyone, wherever you're joining from. I'm Fred Buret, Blockchain Investigation Manager at Recoveries, and welcome to another session of Digital Asset Recovery around the world. In this series, we go jurisdiction by jurisdiction, speaking with practitioners who deal hands-on with crypto disputes, investigations, and recovery. The goal is simple: understand the local landscape, the types of cases arising, and how recovery actually works in practice. Today's format is 30 minutes of discussion, then Q&A. Drop questions in the chat as we go. And just to note, nothing today is legal or financial advice. This session takes us to the Cayman Islands, a key offshore financial center and a major hub for complex digital asset disputes, fund structures, and crypto insolvencies. I'm delighted to be joined by Nia Statham of Baker and Partners. Nia, welcome. Over to you to introduce yourself.
Hi everybody, my name is Nia Statham. I am an associate with Baker and Partners here in the Cayman Islands. I'm also admitted in the British Virgin Islands. I practiced out there for 2 years. I specialise in fraud, work on insolvencies, but have a particular interest in digital asset recovery. And am well placed in the sense that both Cayman Islands and the BVI have a strong nexus to the sector, and I'm very happy to be here.
Brilliant. So let's jump into it. I think we will start with a bit of a landscape of what you see in the Cayman Islands, what is happening regarding the digital assets, and what type of crypto businesses are coming to the Cayman Islands.
Sure. So just for the benefit of the audience, what I'll do is I might just run through some of the basics of how digital asset wealth is generated on the blockchain, how they're stored, what the importance of a legal wrapper is, and how the Cayman Foundation Company has a role to play in that. And then we'll go through a couple more points related to digital asset recovery. In terms of wealth generation, there's a couple of ways, and these are just examples. Blockchain networks can sometimes charge gas fees. Virtual asset wealth can be generated in that way. Mining is purely creating digital asset wealth directly without having to purchase or exchange in order to obtain it. Token launches are another way of generating virtual asset wealth. That's where you issue a token to market. You can sell it privately or publicly, and there will be an exchange and you can generate wealth that way. And then there are DAOs, and there are, in my view, and my experience, there are two buckets for DAOs and fundraising. You can have DAOs that sit against a protocol, adjacent to a protocol. And then you have DAOs which are really just directly fundraising, whether that's for philanthropic or investment purposes. DAOs are decentralized autonomous organizations. They are associations of token holders. Those tokens will carry voting rights. The association normally has a purpose behind it, which I'll speak to in a moment. The operations of the DAO are automated in the sense that, say, for example, the decentralized autonomous organization is running a decentralized exchange. The operations of that exchange are automatic because of the self-executing smart contract technology that underpins it. That being said, sort of software updates, patches, upgrades would require intervention, and that's not automated, or not in every case in any event yet. And then in terms of the decentralization, we normally think of decentralization where the token supply has been allocated in a decentralized way. So good practice is to keep token supplies to 10% or less in terms of concentration. But as we can see from different cases out there across the world, some of these token supplies are anonymously centralized. That can happen at the beginning of a DAO's lifespan when the tokens are issued and people can direct where the bulk of those tokens are going to go. They are held anonymously or pseudo-anonymously across thousands of wallets that can be controlled by one person or a group of related people. And like I said, DAOs as a voting community will play a role in deciding sort of the development of a protocol like the exchange. Separately, they can also just come together in order to fundraise for something. Now, whether that's to fundraise with an expectation that they'll get a redemption, that's a pure investment, I'd say. Then the other is philanthropic and for charitable purposes, where you might come together to raise funds for a particular purpose with no expectation of a redemption. In every single case, these virtual assets will have to be stored in wallets, and whoever controls the wallet is the person with the private key, if we have a setup like that. The other way of controlling a wallet is through a multi-sig arrangement. That's where you have multiple signatories, and you require a quorum of those signatories in order to authorize a transaction. Very typically, and for legitimate reasons, these signatories tend to be anonymous or pseudo-anonymous. If they are dealing with very high-value treasury wallets, that often means that they might be at risk of attacks or anything like that, by bad actors. So to compel or coerce or force a transfer out of virtual assets out of a wallet. The problem from a digital asset recovery perspective, which applies to every single jurisdiction in that circumstance, is that in order to compel a transfer out of a wallet, you need to know who the holder is of the private key, where the wallet is hot and unhosted, or cold and unhosted. But essentially, if we don't know who the signatories are and we don't know who the holder of the private key is, then regardless of what order we get, very likely we won't be able to enforce it against those individuals to compel them to authorize a transfer. The other point is some of these protocols may not be capable of amendment and modification, which means that even if you were to obtain a court order, and even if the controllers were able to do something and try and comply, if the protocol isn't capable of complying with the court order because it just wasn't set up to anticipate that, then that's another enforcement barrier as well. Some jurisdictions are trying to address that in terms of trying to have protocols being capable of have protocols that are capable of modification and amendment, but it's very rare to see that in practice. So why do we need legal wrappers, and what are legal wrappers? We're not in a world right now where we can buy huge amounts of things with crypto directly, and of course that will change the closer we move to mass adoption. So for now, and for different reasons, projects, DAOs may feel it necessary to move digital assets off-chain. Traditionally, we've always thought of that by going through a centralized exchange, but one of the issues with a DAO specifically, or any kind of community virtually, is that they can't provide their know your customer information. They might qualify as a legal person in various jurisdictions. In Cayman, they could well arguably qualify as a legal person here by virtue of the fact that they might be an association or a club. It's never been tested in the Grand Court yet, but that's possible. But they're still in a position where they can't actually provide any onboarding information. So in order to do that, they need to adopt a corporate intermediary, any kind of company. So every jurisdiction offers a legal wrapper, whether they're aware of it or not. In the Web3 space, certain corporate intermediary vehicles are more popular than others, and that's where the Cayman Foundation comes into play, which we'll talk about in a bit. But what do legal wrappers do? So they do offer off-ramping solutions. So they can open accounts at regulated institutions on behalf of DAOs and Web3 projects. They can potentially use credit cards. So there are stablecoin-powered credit cards out there at the moment. They can purchase real-world assets or interests and investments. And they can do that because they have legal personality. They can enter into contracts and they comply with know your customer requirements. To the extent that they don't actually need to disclose that they front a Web3 project. They can also enter into third-party contracts, so that means that they can employ software developers, other service providers. They can be responsible for operational and governance, and they can also enter into transactions to carry insurance or to take out loans. Those are all potential and possibilities of what legal wrappers can do, and you can have more than one legal wrapper in a structure because in theory any company could perform these functions on behalf of a DAO or a Web3 project. Foundation companies have increased in popularity. We've now got around 1,700, which is a jump from 2 years ago. I think from around 700 or so. The jump is partly responsible because the US have started to treat DAOs as sort of general partnerships, which means that the token holders are liable for the acts of the other. The important thing to remember about token holders is that as part of a community, they get to vote on things. And in order for those outcome of votes to be carried out, it might be that the legal wrapper needs to do that on their behalf. A virtual voting community can't necessarily do an awful lot directly. They won't be implementing upgrades themselves directly, for example. They're just indicating what they'd like to happen, and the relationship with the legal wrapper, depending on the proximity, how it's drafted, and what happens in practice, they will action those instructions or indications on their behalf. Foundation companies play a similar role. They have a unique feature in the sense that they're ownerless, but Cayman isn't the only jurisdiction to offer an ownerless company. It just so happens that this vehicle is very DAO and Web3 friendly, and we have a crypto hub in Cayman. So you have these two things converging, which is why we're talking about foundation companies today. The way they're incorporated, they start off life as a regular company, and then they meet a certain set of requirements, and then they're declared as a foundation. At that point, the shares can be cancelled, and a supervisor will step in. There's a director, like a normal company. There is a secretary, which acts like the registered office for the company. At the moment, our Foundation Companies Act expressly states that directors and supervisors can be one and the same. And because corporate service providers can not only incorporate the company, but they can also offer the same services, there is the potential for a corporate service provider, in theory, to be the only kind of face to the company itself, and that will come down to the controller information that's available for the company. There won't be any register of members that's usable because the shares will be cancelled. So the information that's being provided are the register of directors and register of supervisors. There isn't necessarily a link between who's behind a project and who's using the vehicle to access regulated services. So that's one point. The second point, of course, is because there isn't this distinction between a director and a supervisor, the vehicle can be autonomous. Now, in the sense of this structure is very, very flexible. You can customize it. So you can build in as much accountability and supervision as you like, and you can equally scale it back. So everyone is going to be completely different. From a tracing and recovery perspective, we're just talking about worst case scenarios, but that's not a reflection of the industry here, and well-governed DAOs and projects will have built in voluntarily their own sort of checks and balances. But of course, this company in a way can reflect the ethos of a DAO, and that's why it's so interesting. Then you have beneficiaries and interested persons. These are two categories of people that interact with the company, and they're important because the recovery routes will be very different depending on who you are. So beneficiaries of a foundation company have no statutory rights at all against the company, the directors, the management, or the assets of the foundation company. That also means there won't be creditors, likely in insolvency. And in digital asset recovery, insolvency routes are extremely helpful. Running claims, breach of director claims, it tends to be easier than running a fraud claim. All those recovery options fall away if a DAO or a token holder could be inferred to be a beneficiary. And even if the foundation company doesn't designate a beneficiary, the courts could always infer them. So it's really, really important that people who are investing in foundations or in DAOs which are being wrapped by foundations understand who they are in relation to the foundation. The foundation company does have the ability to seek directions from the courts. That's always an option. And the reason why it's important is because the other category of persons that a DAO or token holder could in theory be if they were treated as legal persons, we don't know yet, but there is an argument for it, is that they could be interested persons rather than beneficiaries. And they do have different rights. They've got information rights. They can ask for explanations by the director for how the foundation company is running. In some instances, they can bring applications on behalf of the foundation company. In certain circumstances, there may be the option to wind the company up. So there are clearer statutory routes and recovery routes available, particularly because there's also a statutory clawback provision in our Foundation Companies Act 2. If you go down the trust route, there are things that you can apply for. So, for example, equitable compensation, where you can ask for the Treasury wallet to be reconstituted, but that's not the same as being able to get disbursements or refunds out of the Treasury wallet. That's something separate. So it can get quite costly and complicated in theory if that were to be the case. So it's not all doom and gloom, but they're very drastically different recovery routes available depending on who you are in relation to the foundation. In terms of the practical tracing issues with foundations, and these apply actually to almost every single legal wrapper in the world. And actually, I'm not going to say these are tracing issues specific to foundations. I'll point out specifically which one does. But generally speaking, and as far as I'm aware, most jurisdictions don't require a disclosure by the company of whether it's wrapping a project. Most jurisdictions don't offer or require a register to be kept, a publicly searchable register, or a searchable register subject to a fee being kept and maintained, which shows which projects are wrapped by which company. There's also no requirement in most countries that a company name include or reflect the name of the project it's wrapping. That's important from a tracing perspective because you want to be able to establish a nexus between both. If there's no requirement to do that, then ABC Limited might be wrapping Coffee Dow. And you can't put the two together just by looking at them both in that sense. You're going to have to do a lot of digging potentially to establish a nexus, and that digging will depend on lots of things. There are proposals that you can look at. The constitution of the company is filed with the registrar of companies here, but the bylaws are private, and that again goes to the importance of information rights. So in terms of investors being able to do their due diligence, it's a tracing issue that applies across the world. Also, obviously, from a backward tracing perspective, because regulated institutions aren't requiring this information either, you could find yourself an investigation being directed to this company and miss the fact that this company is a front for a project or a DAO. I call that like a backward tracing issue. So that's why collecting that information is really, really important, purely from an asset recovery and tracing perspective. Cayman Foundation companies and any ownerless company likely, there is this issue with the KYC in the sense of the controller information is taken where there's no beneficial ownership of information available. But where that controller information may lead just to a corporate service provider, it won't in every single case at all by any means. But because this potential, that's why I'm talking about it. It means that you'll likely need to do two disclosure applications. One for the institution which has taken the KYC, if they're regulated or if they're taking it voluntarily, and then another to the corporate service provider to understand who their ultimate client was. Doable, but increase the costs of digital asset recovery. And then that means that might price people out of being able to sort of get the relief that they need from court. And then that's a funding point. So that's an important consideration, I think. And then I suppose just to kind of underscore the issue generally and why the setup at the moment can cause problems. We actually had a worst case scenario happen in the UK last month where we had two UK registered companies sanctioned by the US Treasury for operating a cryptocurrency exchange, which was being operated by a sanction evader associated with Iran, had processed around $94 billion in transactions and had moved its estimated around $1 billion for the Iranian regime. Again, this activity is an in-scope activity in the UK. They didn't register, they didn't license as a virtual asset service provider. And they pretty much were able to do this under the radar because just for this reason, because people, I suspect, aren't asking enough questions. And it's very easy to evade regulatory oversight when you're just using regular companies to do this. So the US Treasury actually designated these companies as operating in the financial sector of the economy of Iran from the UK, which is amazing. And they were also deemed to have materially assisted, sponsored, or provided support for goods and services in support of Iran. So again, the UK has a robust virtual asset service regime, but because of the role that legal wrappers can play, and because there's not an awful lot of education or awareness around them, worst case scenarios like this can happen, and they do happen. And notably, it's happened in an onshore jurisdiction. So again, just kind of reinforces some of these tracing issues. These companies would have opened accounts at banks. Interestingly, these companies do actually have the word exchange in them, which signifies a trade, but you can see how easy this would be if it was ABCD Ltd. And then there's no real indication of what they're doing. But they would have opened accounts, and they could have made transfers, washed those transfers before they reached those accounts too, in fiat. So yeah, all really, really interesting. In terms of the tracing and recovery tools that are available, particularly in Cayman, I've mentioned, depending on who you are in relation to the foundation company, there are some statutory recovery options for you, which you can bring if you're an interested person. That is not available to you if you are a beneficiary. So try to work out who you are and how you're going, what your recovery routes are going to be in relation to the foundation. I think that's important at the outset. Norwich Pharmacal orders, these are available. These are disclosure orders that we can make. We can make banker trust orders. Anton Pillar orders are essentially physical seizures, so sort of cold wallet storage devices and things like that. Computers, and then you can run a scan to see, where the private keys are or how they're hidden or sharded and concealed. Receiverships here are also an option. Generally, receiverships can be used to support a freezing injunction that you can also obtain here. And a receivership will be appointed to kind of hold the ring while the freeze is in place to kind of police that freezing order. And then obviously we've got, trust claims, fraud claims, and just enrichment. But again, those recovery options will vary depending on who you are in relation to the foundation company. So I hope that kind of gives you a whirlwind tour. I appreciate we were also meant to be discussing sort of emerging crypto-related matters and stuff, and I don't know if you'd like me to move on to that.
Actually, I had a couple of quick questions on what you said, because it's very comprehensive. But so my understanding is foundations can be supported by legal wrappers. So you have the DAO composed of people who are holding the tokens, but also people who are holding the tokens and involved in the management of the project. So pushing out the decisions for the vote, and then actually using the funds to and action what the decisions that were taken via this vote. And I feel there's no dissociations of the two. Of these two type of parties, some who are taking the decisions by voting, purchasing a token and participating to a vote, and those who are actually doing the actions and putting the responsibility of the DAO on in the real world, like by spending crypto, but also by spending real money and upgrading a contract, for example, which could have real world consequences for investors.
Yeah, and that's right, to the extent that the Cayman Foundation Company is a legal wrapper, and it can be a legal wrapper, but also it will commonly sit at the top of a structure, corporate structure, and it will own the token issuer, or it will own and control the token issuer. And it may own different, an operating subsidiary, a subsidiary to hold IP. All these things may be spread across. It might be that other entities in the structure perform some of these roles. The foundation company, as well as any other legal wrapper, can perform treasury management activities as well. So they might be a signatory to the multi-sig. They might be dealing with the assets of the DAO. They might also separately have their own wallets, and those digital assets belong to the foundation company. But arguably, and particularly if there is this trust relationship, because the foundation company is a quasi-trust civil foundation company, it could well be that it's dealing with assets on behalf of a DAO, and that applies to any other legal wrapper as well. It really depends on what everyone is doing and what the relationship is. At the end of the day, the directors owe duties to the foundation company. They don't owe duties to anybody else unless their constitution has a set of objectives and it makes it clearer who they're acting for. If they're trustees, then that's different. And the foundation company itself may be a trustee, but directors specifically owe duties to the foundation, and they can follow instructions from a DAO, but ultimately it's up to them if they're going to execute those instructions, because they still have an overriding duty to the foundation company. However, really depends on how the relationship between the DAO has been documented and how it is in practice with these different corporate intermediaries, these touch points, because they might all play a different role within the structure, or it might well be that they are being wrapped by one entity, and then this entity will instruct other entities within the group to do something, or they'll engage in third-party contractors. But you're absolutely right. The point is that they're meant to be actioning things, proposals that have been passed by a DAO. They're meant to be implemented in the real world on their behalf, and that has to happen really through a legal wrapper, whether that's a Cayman Foundation company or a subsidiary. The same applies for any other jurisdiction. It's a lawyer answer, but it really just depends on what everybody's doing, and so many of these functions can be outsourced to different providers. But I think one of the keys is to understand who's contracting with who on behalf of the DAO, and that probably helps establish a stronger anchor to a particular jurisdiction.
Yeah, and I was thinking in terms of investigations, there's on the tracing aspects, you may be able to link some of the actions that are done through these legal wrappers to decisions that have been taken to the DAO, and maybe some of the individuals that you can link to the management of this DAO on the Discord or the forums that they're using to communicate between each other, which may lead to real world entities, individuals who are active and could be a source of information, or could be target for more aggressive legal actions.
Absolutely. But there's also a risk of disappearing messages, because it could well be that people are using those. That's not a good idea for directors, because they should be documenting what they're doing from a governance perspective. However, when we're in asset recovery, we're generally talking about worst case scenarios and where the risks are for that. So it could very well be that actually instructions are being taken by project insiders, because remember, the whole point of and the full issue of having an anonymously centralized DAO is that even if you were to put a proposal to the community, the outcome of that vote is predetermined, because the voting supply has been centralized anonymously. So it really doesn't matter what you say, it's going to happen. And that's important, because these votes can sometimes concern treasury management and where these funds are going. And it's important to remember that all these fundraising activities are completely without any regulatory oversight until there's a touch point with a legal wrapper. So all this fundraising is happening more or less autonomously. And I think it's important, because where tokens are being issued in an unregulated jurisdiction, so for example, there's no good standing requirements, there's no licensing requirements. So for example, if you're caught to have misled investors, then that doesn't mean you're going to have your license revoked and you can't do this anymore. Very often in practice, from what I've seen, I've come across many issuers in Panama and BVI, because the act of issuance isn't regulated. That's great for innovation and legitimate projects. Many start off life there because they're like jurisdictional sandboxes. The other side to that is it's also attractive to bad actors, because there's no accountability, and there's no statutory requirements there for investor protections, for creditor protections, for marketing. So all that's really, really important at the issuing level. And it's important again to note that if these legal wrappers are holding companies of issuers, then you're printing your own money, you're selling it to the world, or you might be operating a protocol which is generating fees from the deposits that are made. Either way, it's fundraising. If the governance tokens are centralized, then that virtual asset wealth, what happens to it is kind of predetermined, which is kind of why decentralization of these associations was such an amazing idea, because it was meant to eradicate the risk of anything like that happening. But the reality of it is you do have these control points. The controllers of the multi-sig wallet or the wallet, they're the people that we need to enforce against. Potentially, we'd need to enforce against anybody who can compel either a change in the protocol, for example, or a transfer out of the Treasury wallet, because we need to ring-fence these assets at the end of the day. And if a DAO isn't compliant, or if a lot of the community have abandoned the DAO, because people lose interest as well, even if the DAO is decentralized, then we've got an enforceability issue. I believe these things can be managed, and they can be mitigated. And we can look to other jurisdictions who are already tackling these issues. The US has brought out a couple of states have brought out some bespoke legislation for DAOs, for example. But we don't have anything like that in Europe, UK, offshore yet.
Yeah, we're playing catch up, I think. I'm aware we have gone over time by nearly 4 minutes. If anyone has any questions, please feel free to use the chat. But I don't see any at the moment. Do you want to give a quick comment on what you think is gonna happen, like this crystal ball predictions, especially on DAOs, and what would be the next step?
I think lots of jurisdictions are playing catch up, or they might be looking to other jurisdictions to see what they're doing. So it could be that some jurisdictions start following what the states are doing. In the US, 18 states have criminalized unlicensed trading platforms. That might be one way of going through it. Particularly here in Cayman, the majority of our foundation disputes are going to arbitration, which is private. So there might be lots of really interesting arguments going on, but we don't have any published decisions. So that's one thing. And then in terms of sort of the regulatory trends that are coming through, our phase 2 came in this year, which means that there's now a licensing regime for virtual asset service providers. So particularly for trading platforms and custodians, we did have a registration phase 2 that, but now there's a licensing. Then what's coming up in phase 3 will be the sandbox regime. And I think SEMA started issuing some supervisory notices to foundations as well, because there is a recognition that companies might be performing in-scope activities. But I think those are just information requests. That doesn't mean that anyone's done anything wrong at all. But again, because there's no distinction between the director and the supervisor, because it's possible to strip back checks and balances, it could be that, or it could be quite easy for foundations, for example, and any other company as well, which has the similar setup, to not register as a VASP when it should be. These are just issues that we'll work through, I think, in order for TradFi and DeFi to blend together more effectively. But where it's not blending, we have examples like the ZX Exchange case in the UK, where entities end up laundering $1 billion in an otherwise well-regulated jurisdiction because there is this regulatory blind spot that probably needs addressing.
Yep, noted. We also probably need a DAO court adapted to respond and able to freeze some funds remotely. Someone was typing a question, but if it's not coming up, so if you have any questions about recommendations for preparing recovery proceedings before the Cayman Arbitration Mediation Center. any recommendations related to digital assets, I guess, to prepare recovery proceedings?
Sorry, so is that a question?
Yes, sorry, I will repeat. Matei is asking if you have any advice or recommendations for preparing recovery proceedings before the Cayman Arbitration Mediation Center.
Right, okay. Well, so I can't give legal advice or anything like that. Obviously, get your independent legal advice. I think that's a really important point as well, because you don't know potentially who the project insiders are. They may have obtained legal advice, but their rights and interests will be different to potentially investors who aren't insiders. And that's why it's always really, really important to know who you are in relation to the foundation. In terms of preparations for an arbitration, I think making sure that you've preserved all your documents, that you've got the documents to hand that you need, that you're clear on what your case is, that you're respecting the rules of the arbitral tribunal, and respecting the arbitral process. That's a private process. And I suppose the query, I guess, would need to be a bit more specific for me to answer more fully. But again, not legal advice, just for practical points.
Yeah. Well, thank you very much, Nia. We'll wrap up. And thank you, everyone, for joining us today. Please do keep an eye on the Recovery's LinkedIn page for announcement on next episodes. We're currently planning on upcoming sessions with law firms based in Singapore, Bulgaria, Hong Kong, Spain, and Ukraine. So later in the year. I'm very excited to continue exploring how digital asset recovery plays out across different jurisdictions. And thank you again for joining us, and we look forward to seeing you at the future session. Bye-bye.
Thanks, Fred.